State Gambling Commission. We are in person and virtual at the Washington State Liquor and Cannabis Board at 9:35 a.m. The August Commission meeting is likely only going to be one day instead of two, starting with the petition for review. We will likely adjourn for executive session around about 11:30 and reconvene at 12:30. If you have any questions regarding the meeting, please contact Julie Anderson at julie.anderson@wsgc.wa.gov. The telephone lines are currently muted. When I ask for public comment, raise your hand and staff will unmute your line. You may then provide your comment and remute your phone. Please do not interrupt individuals who are speaking. Each person will have the opportunity to comment. However, I may limit the amount of time allotted per speaker if necessary. When you provide your comment, please clearly state your name, your contact information if you would like to receive a summary of all comments and who you are representing. Today's meeting will be recorded. So I will now take roll. So we have Vice Chair Patterson here. Commissioner Sizemore is in the room. Commissioner Lawson. Commissioner Lawson. Hear me? Yes, there you are. And Commissioner Ibsen.
Here.
Great, thank you. Senator Conway. Senator Conway, are you here today? Senator Holy? And I don't believe Representative Koba or Representative Rude will be here today. We will go ahead and start with the consent agenda. Yes.
Madam Chair, can I make one clarification on the minutes?
Yes.
So on page 4 of the packet, under tab 5, the recording of the votes showed Commissioners Lawson and Ibsen abstained, and I believe that meant to be opposed.
Oh.
So with that adjustment, I would move the consent agenda as soon as we take public comment.
All right. Is there any public comment on the consent agenda?
Well, and Chair, not that I'm giving public comment, but you may want to, is that confirmed with Commissioners Lawson and Ibsen?
That is confirmed, and I'll second the motion as modified.
Okay. Just wanted to get that on.
All right.
Yes, I'll confirm as well.
Thank you.
Thanks for catching that one.
So the motion has been moved and seconded with the one change to tab 5 of the minutes. Are there any additional comments? All right, all those in favor say aye.
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 Great. Now we will move to the director's report.
Good morning, Commissioners. So with this month's report, just wanted to share a verbal report. In July, I, along with some of you all as commissioners, as well as 3 representatives from the Gaming and Regulated Substance Committee of the legislature, attended the National Council of Legislators of Gaming States. That conference was in Denver, and while the meeting is geared towards legislators, many regulators attended as well. And so just a quick overview of the topics that were presented. We attended a Colorado Gaming Board. They actually invited us to the regional meeting that they hold quarterly with law enforcement as well as college athletic departments of that area. It was a very good meeting. We discussed what was discussed at that meeting was the education done by the colleges to their athletes, not only on sports wagering, but more specifically the challenges that they're facing currently, which are how to handle the threats and harassment that those athletes are encountering from easy access to those athletes through social media. So very, very serious situation that's happening with that now, with the prevalence of sports wagering throughout the country. Some of the other conference program notes were GLI came and spoke to regulators regarding trends and forward-looking changes in gaming. We also had a sports wagering regulators group that was recently formed, and so that we were able to participate in that. And again, these are just some of the many meetings. There was also the Responsible Gaming Committee. They presented their resolution that was passed by the National Council, and we will be discussing that resolution on problem gambling further under tab 8 today. Representative Stearns and Representative Wiley facilitated a panel on tribal operators moving to be commercial licensees. Representative Kloba was not able to attend, but she was supposed to be the panel leader, but I know she's part of NICLG's and has participated on various committees. And then I had the opportunity to participate on a regulator-legislator panel, and we discussed how we work together, both as legislators and in our separate roles. It was a very good discussion, and I shared that we focus on educating legislators in terms of what we do and what is authorized in the state, a few different ways, one being Gambling 101, and I know that one of the senators was interested a little bit more in that, and in fact we're already in the planning stages to offer that to legislators and legislative aides and staffers this fall. We're starting to prep that already. So it was a great conference, and it was wonderful to see so many. I mean, we would have had would have had 4 legislators from the state, and I think that was just a very good turnout. So thank you for that. That's all I have, unless you have any questions.
Great, thank you. Okay, next we are going to move to the petition for reconsideration. As Doug Vanderbrake with here.
Yes, I'm present.
Perfect, thank you. And Frank, I believe I see you there. So we're going to split this into 2 parts. The first part, I will give each side a 5-minute oral argument to determine whether or not we should allow in the evidence that was submitted prior to the last meeting. And then the commissioners will break into executive session, let you know what that ruling is. Then we will allow each side 10 minutes of oral argument on the actual petition for reconsideration. The commissioners will break into executive session again, and then we will let you know that ruling. So if you're ready to begin, we'll start with Mr. Hugenin, and you will have 5 minutes starting now.
Yes, thank you, Madam Commissioner. It's good to see you all again. I was not prepared on this initial motion, but I think I can adequately address this. With respect to the motion for reconsideration, Exhibits 1 through 6 are all matters of public record, and that's just to identify to the court and present as part of the record the issues that I raised post the pleadings closing for the initial petition for review. They were brought up in the context of oral argument, but a lot of the events that transpired only occurred after the pleadings had closed. And so that is to further establish the arguments I made orally regarding the disposition, for example, of the administrative charges related to Hector Enriquez. Importantly, there is, as Exhibit 5, a pre-hearing conference order in this particular touch matter that I wanted to draw the Commission's attention to as it relates to the conversation that we're having here today, specifically in oral argument. My recollection of Mr. Vanderbrake's position was that prior counsel did not conduct any discovery. However, based on my review of the pre-hearing conference order, no discovery was actually permitted in the touch matter. And I think that's important because there is now the additional exhibits that were provided on reply. And I want to address that in the context of a CR 59 consideration, and that's specifically with newly discovered evidence. The caveat to newly discovered evidence is that it would have had not been discoverable by reasonable efforts of the party. prior to the CR 59 motion. And Ms. Touch asserts that that's the case here for a variety of reasons. First, with respect to how I obtained this to a public records request that I actually submitted back on, I believe, on or around January 24, 2022. It took a year and a half for the Gambling Commission to produce this, and even then when it was produced, they tried to conceal critical components that I brought to the Commission's attention by way of the reply material. Additionally, it would have arguably been exempted under the exemption for an active investigation. And finally, because no discovery period was provided, Ms. Touch would not have been able to, even through prior counsel, make an interrogatory or request for production for that purpose. So for that reason, the text messages that show the collaboration, the conspiring between Agent Ronnie Cooper and two of the key witnesses, Mr. Martin and Mr. Stroud, in this matter, asking for non-direct help that then led to a couple months later, administrative charges being filed against one of Ms. Touch's key witnesses that then Doug Vanderbrake utilized to discredit Mr. Enriquez and then also intimidate Mr. Enriquez should be admitted into the record so that way we can preserve this issue for appeal should the Commission deny Ms. Touch's motion for reconsideration. Thank you.
Thank you. Mr. Vanderbrake?
Thank you, Commissioners. Mr. Huguenens, in response to Mr. Huguenens' claim that this case did not allow discovery, he is wrong. Mrs. Touch's attorneys had 2 opportunities to request discovery. That's what is in the record. At the initial pre-hearing conference on November 19th, 2021, the attorneys for the parties had an opportunity to request discovery schedule be built into the case schedule. Mrs. Touch's attorney did not request discovery. This is from the record. The administrative law judge questioned Mrs. Touch's attorney. Anything else that we need to put into your case schedule? Mrs. Touch's attorney's response was, no, Your Honor, that's it for the case schedule. Subsequently, Mrs. Touch's attorney had a second opportunity to request discovery for this case schedule, but did not do so. That occurred on February 9th, 2021 at a status conference in which Ms. Touch requested a continuance of the hearing and more time to file a witness and exhibit list. At that status conference, and it's what's in the record, the judge asked Mrs. Touch's attorney, I quote, so I want to confirm, Mr. Guadagno, you're asking me for 2 things, a rescheduled hearing date to give you time to prepare and a rescheduled submission date for appellant witnesses, witness and exhibit list and documents for basically the same reason. Are you asking for anything else besides those? Answer, correct. Question, are you asking for anything else besides those 2 things? Answer, I'm asking for only those reasons, Your Honor, and for those 2 purposes. So the parties had an opportunity. Mrs. Touch had more than one opportunity to request that a discovery schedule be built into the case schedule. She did not. Now, regarding the screenshots of text messages that were attached to Mrs. Touch's reply to the staff's response to the motion for reconsideration. It's important for all the reasons we argued in our petition for review when Mrs. Touch tried to introduce exhibits that were not on the record. The Commission's review, in this case, is limited to the record that was created at the evidentiary hearing. Okay, and just like the previous decision that the exhibits that were not part of the record should not be considered, so too should these screenshots of text messages not be considered. They're simply not part of the record. Furthermore, it's very important to consider the dates that were relevant in this case to show that those text messages and screenshots have no relevance to the dispositive fact that was on trial here, and that dispositive factual issue was whether the overpayments occurred as alleged. Okay. Now, The overpayments occurred on August 2nd, 2021. Commission staff opened the investigation on August 10th, 2021. Staff's investigation was completed on September 28th, 2021. The notice of administrative charges were issued on October 19th, 2021. Those screenshots of the text messages are communications between an agent who had no involvement whatsoever into the investigation of the overpayments at issue in this case. The agent in those communications of the screenshots of the text messages was conducting an undercover criminal investigation involving various players and other licensees, not Mrs. Touch or Mrs. Chan. Those screenshots of text messages simply have no relevance to the factual issue here. That concludes my response unless there are questions. Thank you.
And commissioners, I do request just a brief minute to provide a reply to what was just stated there by Doug Vanderbrake.
You have 1 minute and 18 seconds left of your 5 minutes.
Thank you very much, Madam Commissioner. First, Mr. Vanderbrake has not entered into any sort of written pleading the alleged statements that he asserts were made in these evidentiary hearings, so that needs to be stricken as part of his argument. Second, we are here on a CR 59 motion for reconsideration, and it specifically envisions newly discovered evidence. What we are here arguing is not the allegations that were made against Ms. Touch. That's not what we're here for. We're here presenting this evidence to establish the bases under CR 59. CR 59A2 addresses misconduct of the prevailing party, and we've addressed that on pleadings. I'll address that in oral argument as well. Importantly, CR 59A4 addresses newly discovered evidence. Even taking what Mr. Vanderbrake says as being true about no discovery period being requested, perhaps the attorney didn't realize he had to. The reality is, as Doug Vanderbrake just indicated, there was an active investigation going on. Even had she requested it, it would have been exempted from any sort of production, which is why it took 1.5 years for me to get it through a public records request.
It's your time, sir.
Okay. And I appreciate your time and consideration on this matter.
Thank you. The commissioners will now break to executive session. Okay, good morning. We are back, and just a quick clarification that we were in closed session for our deliberations and not executive session. Okay, and back to the evidence. We have decided that we are not going to allow the evidence that was presented at the last hearing. We're going to move forward on the existing administrative case for the motion for reconsideration. So we will start again with Mr. Hugenin. You will have, or let's make sure Commissioner Lawson and Commissioner Ibsen are back. Sorry.
Madam Commissioner, am I able to understand the basis for the denial?
You'll receive an order prepared by staff at a later time.
All right.
And I see Vanderbrake. Are you here? Just want to make sure you're back.
Yes, I am.
Okay, perfect. Okay, so we will go ahead and start with each side. We'll have 10 minutes. We'll start with Mr. Hugenin on the motion for reconsideration.
Thank you, Madam Commissioner. I respectfully request a reservation of time of 3 minutes for rebuttal. After a hearing on the written materials related to Ms. Touch's petition for review, this commission decided to confirm as a final order the initial order from the Office of Administrative Hearings in this matter. However, after the pleadings were closed on Ms. Touch's petition for review, there were certain events that occurred and certain additional pieces of evidence that were discovered which pertain to the arguments made by Ms. Touch in her petition for review. Ms. Touch asserts that this additional information and evidence warrants reconsideration of this commission's decision from April 13th, 2023. CR 59 provides multiple bases for this reconsideration due to certain acts that have been specifically laid out and evidenced on motion and reply. Ms. Touch will rely on these pleadings to provide greater detail. That said, the general takeaway for consideration by this commission is that its staff and Attorney General Doug Vanderbrake engaged in unlawful acts to intimidate and tamper with one of Ms. Touch's key witnesses, Hector Enriquez, in an effort to curtail her defense and in furtherance of a conspiracy to harm Mr. Enriquez and those with any perceived loyalty to him. We now have direct evidence, which I understand you guys have stricken, that has occurred by way of the critical text messages between Steve Martin and Special Agent Ronald Cooper. These messages were only produced as a 10th installment to a public records request that was submitted to the WSGC back on January 26, 2022. Even then, the original 10th installment production on or around June 7, 2023, sought to conceal the substantive portions of these communications through omission and unlawful redaction. I then had to spend the next month to obtain the actual records, which only occurred in the middle of July and just about a week before the last hearing in this matter. This incident, as you likely know, I also represent Corporate Recoveries Incorporated and certain civil actions being adjudicated in King County Superior Court. This incident between Ms. Touch and Sophie Fall-Chan is a central event to those cases and part of the conspiracy I previously mentioned. At the time of filing, the WSGC's role in this conspiracy was not known, and I should specify the WSGC staff's role in this conspiracy was not known. Now we have direct evidence, which this commission has sought to turn a blind eye to, confirming that as far back as 2021, Special Agent Cooper was actively involved in efforts to get rid of Hector Enriquez and his team, including Ms. Touch, in coordination with the very same witnesses that are being sued that the WSGC staff has relied on in presenting its case in chief. To wit are Stephen Martin, Yenzin Jane Wang, and Richard Stroud. This effort extended into last year when Mr. Martin then requested non-direct help from the WSGC and Agent Cooper, which again, this commission has sought to turn a blind eye to, that resulted in notice of administrative charges being brought against Mr. Enriquez mere days before they knew Mr. Enriquez would be testifying in Ms. Touch's matter. Then Doug Vanderbrake goes so far as to question Mr. Enriquez about those very charges, which were filed 6 days before this testimony. And this is after Doug Vanderbrake had Agent Maxwell come to the hearing specifically to be present while Mr. Enriquez was testifying on behalf of Ms. Touch. And it was so disruptive that the administrative law judge ultimately had to ask Agent Maxwell to leave. These are inappropriate acts of intimidation. The reality is, in this case, the WSGC staff failed to prove any of the volitional acts against Ms. Touch. Regardless of what Doug states about a former counsel not asking for a discovery period, the reality is no discovery occurred in this matter. Yet they're hinging this on her asserted character and fitness, which is exactly what Hector Enriquez would have testified to had he not been essentially shocked with fear to have first Agent Maxwell appear at a hearing that he had no business being in, to then have Doug Vanderbrake inquire about the Gambling Commission going after his license, which Mr. Enriquez did not even know about at the October 11th hearing. Then for Mr. Enriquez to be served with those very administrative charges mere days later had a chilling effect. And frankly, it was done because Doug Vanderbrake, I think, knew he was going to lose on the other aspects of this case with respect to the volitional acts of theft and cheating that were asserted against Ms. Touch. This is a sham. The reality is Ms. Touch deserves a fair day in court. She deserves to be able to have meaningful discovery. She deserves to not have an opposing party that has way more power, way more money, way more resources to be able to pursue this, to take essentially what we assert are illegal acts against her in order to curtail her ability to provide any sort of meaningful defense. I want to go over the timing that Doug brought up in the last motion. The timing of the text messages as it relates to the hearing is not what's before this court. The timing of the text messages as it relates to the actions taken against Mr. Enriquez, actions that then resulted in questions to chill Mr. Enriquez's testimony on the stand, is what is before it. And we're talking about a 2-month difference here. The reality is that occurred. At no point has Doug Vanderbrake denied that Agent Maxwell appeared and was asked to leave. At no point has Doug Vanderbrake denied that he questioned Mr. Enriquez on these very charges. And the reality is Mr. Enriquez, prior to that October 11th hearing, had another day scheduled, or excuse me, after the October 11th hearing, had another day scheduled to come and testify. And because of the culmination of these events, he was scared to do so for fear of his own livelihood, for fear of being attacked. And frankly, as the charges of Mr. Enriquez are concerned, we provided a absolute thorough review on that, showing that there was actually quite literally made up false stuff in those charges. We submitted discovery on those made up false charges. And wouldn't you know, the Gambling Commission staff refused to respond to the discovery. They continued to delay and delay. And then after the pleadings were closed on the initial petition for review, the Gambling Commission staff dismissed the charges against Mr. Enriquez. No explanation whatsoever, but they did it.
That's your 7 minutes if you wanted
Thank
to.
you. I'll
Thank
reserve
you.
the other 3. Actually, no, I'll reserve 2, and I'm going to go 1 minute more, please. At the end of the day, we're here on CR 59. CR 59 A2, A4, A9 provide more than enough reason for this commission to do the right thing here and actually give Ms. Touch a fair trial. There's been misconduct of the prevailing party. There's been newly discovered evidence which would not have been discoverable by any reasonable efforts of Ms. Touch, even if she had a discovery period, and substantial justice has not been done. She deserves her fair day in court. She has not been found guilty of any of the volitional acts, and all she wants to do is show that she is suitable with character and fitness to be continued for licensure and her chosen career. Thank you.
Thank you. You will have 2 minutes and 15 seconds for rebuttal. Mr. Vanderbrake, you can now begin your 10 minutes.
Thank you. This is not a Public Records Act case. Right? What we heard from Mr. Huguenin is speculation, conjecture, and personal attacks. We did not hear citations to the evidentiary record and what the trier of fact found and concluded after 9 days of hearing. We've heard all about Mr. Enriquez. This case is not about Mr. Enriquez. As in Mr. Enriquez, it's important for the commission to hear the facts that are in the record. Okay. First off, during the trial, we're hearing it's an adversarial system. Mr. Enriquez did testify. The commission staff's counsel, me, never had an opportunity to cross-examine him on the record because he repeatedly refused to appear. These are the facts. He testified on July 27th. That ended up being one of the 2 days that the Office of Administrative Hearings lost the recording of the hearing. The administrative law judge then ended up scheduling 4 more days to allow Mrs. Touch to present her case, specifically for Mr. Enriquez to reappear to testify. They set up September 16th and 28th. On September 16th, Mr. Enriquez did not appear. Mrs. Touch's attorney informed the judge that he would appear on September 28th. On September 28th, Mr. Enriquez did not appear. Mrs. Touch's attorney informed the judge that October 11th works better for Mr. Enriquez, and then Mr. Enriquez told him that day he is available. On October 11th, Mr. Enriquez did appear to testify for Mrs. Touch. He testified from 11:09 a.m. to approximately 1:03 p.m., then told the judge that he had to leave. The judge then set up yet another day for Mr. Enriquez to testify and to confirm that October 24th he would appear. He failed to appear. This effectively prevented staff counsel from cross-examining Mr. Enriquez. Those are the facts. That's what's in the record. The other fact to keep in mind here is that the dispositive issue of fact in this case is whether the overpayments occurred. The judge presiding over the hearing had the opportunity to hear from each side's witnesses and to consider the exhibits. Mrs. Touch's attorneys never filed any exhibits. That's what the record shows. What it shows, the judge heard testimony from a dealer next to the table where the game of Baccarat was being played. She reported suspicious activity to a supervisor. She thought she saw some overpayments. Now, when the shift or floor supervisor at the casino, who wasn't there at the time, arrived later that evening, Mrs. Stevens, who Mr. Huguenin also represents, Mrs. Stevens, when learning of the report, went to the surveillance room, and along with Mr. Stroud, the surveillance manager, observed a portion of the video. And Mrs. Stevens concluded that, at least for the part of the video she reviewed, the overpayments occurred. She documented that then in an email message that went to the casino general manager, Mr. Enriquez, and to the chief operating officer, Mr. McCarthy. So Mrs. Stevens, now this is in the record, okay? This is Exhibit 6 at the evidentiary hearing. It shows this email correspondence from Tiffany Stevens concluding the overpayments occurred. The trier of fact, which was the administrative law judge, also heard from the on-site surveillance manager, Richard Stroud, about his review of the video surveillance footage. He also heard from an off-site regional surveillance manager for the casino, who also testified that the 14 overpayments occurred. And the trier of fact heard from Special Agent Jess Losey, who was the only agent involved in this investigation, and heard how Mr. Losey testified that in his review, he observed at least 12 overpayments occur instead of 14. So all told, in the record, you have 3 people who testified about what the video captured. All right. And the judge, making credibility findings and hearing that evidence and considering the exhibits, reasonably concluded, the only reasonable inferences from this is that the overpayments did occur as alleged. Okay. Those are the facts. Finally, I want to point out here, the underlying theme here is that Mrs. Touch poses a threat to the effective regulation of gambling, and that's a basis for revoking her license. Now, this is information that's in the record, okay? She has prior administrative history. In May of 2013, she received a notice of violation for underreporting her tip income to her employer. In July of 2018, she received a notice of infraction for failing to follow Baccarat game rules. In July of 2020, she received a notice of violation, again, and fine for again failing to follow Baccarat game rules. In June of 2020, she received a verbal warning for loaning money to a player. Now, licensees are prohibited from providing credit, gifts, or loans to players. Now, subsequent to the administrative charges in this case, Mrs. Touch and then Mrs. Chan, her friend who was a dealer, they were discharged from employment at the Iron Horse Casino for suspicious behavior regarding Baccarat games. These are facts that are in the record, okay, and it demonstrates that Mrs. Touch is not qualified for licensure. She did not meet her burden to show that she remains qualified for licensure, and for those reasons, staff respectfully request that the commission affirm its final order denying the petition for review, which did affirm the administrative law judge's initial order. Thank you.
Thank you. All right, Mr. Huguenin, you have 2 minutes and 15 seconds.
Thank you. First of all, I think it's kind of ironic that that Mr. Vanderbrake would bring up the statement of Ms. Stevens, because he's had the benefit of now deposing Mr. Enriquez on these very issues, and some very serious disparities existed in that statement from Ms. Stevens. And what Mr. Vanderbrake will find out when we depose Ms. Stevens in the sister case is that, in fact, she was forced to write that statement under duress, and that certain telltale signs of that statement have already been noted to Doug, but he chooses to rely on that. Nevertheless, the other issues that he raised about alleged past behavior, that wasn't adjudicated in this matter. You know, he brings up the notice of infraction regarding tips and verbal warnings. Those weren't adjudicated with any sort of you know, hearing or discovery. What the reality is that at the end of the day, Ms. Touch had a legal right to be able to bring a fair defense to this matter. At the end of the day, even now with this rebuttal, Mr. Vanderbeek has not denied that he used the administrative charges to question Hector Enriquez on. At the end of the day, the reality is those charges were brought up mere days before the October 11th hearing, and I'll mind you, just a couple of months after the text messages that you seek to strike. And I just want to tell this commission point blank, the truth is going to come out in this matter. The commission can continue to turn a blind eye, or the commission can do the right thing and give Ms. Touch a fair hearing. But it will come out, and it's going to happen either in this administrative hearings or it's going to happen through future litigation. So the choice is your guys' as far as I'm concerned. All I'm doing right now is trying to establish a record, but I feel like Ms. Touch is not getting a fair shake in these proceedings, and you guys are willfully ignoring evidence about certain acts that your agents engaged in inappropriately to try to further unbalance the scales as it relates to a licensee going against the commission when the commission is trying to take away her livelihood. So again, the choice is yours. Thanks.
Okay, we will again go into a closed session for our deliberations, and we will be back shortly. Okay, we are back. Let me just make sure we have Commissioner Lawson and Commissioner Ibsen. Are you here, Commissioner Ibsen? Okay, see them both here. So thank you both for your arguments. At this time, we are going to deny the motion for reconsideration and affirm the final order. So you will receive an order from the commission probably sometime early next week. Thank you. Next up, we have tab 3, which is presentation of the Special Olympics of Washington. I believe we have Tony Czar, Mary Doe, and Mark Sine. You're all here?
Present.
Here.
Okay.
Good morning, Chair Levy and commissioners. For the record, my name is Tony Czar. I'm an agent assigned to the regulation unit, and I'm here this morning to report on the results of the fall 2022 enhanced raffle conducted by Special Olympics of Washington, and to introduce Special Olympics of Washington and their proposal for the 2023 Dream Adventure Enhanced Raffle. Details of both of these matters are set forth in tab 3 of your commission packet, and in terms of the proposal, we will require action today. With respect to the fall 2022 Dream Adventure Enhanced Raffle, the grand prize drawing was conducted on December 2nd, 2022, and was attended by commission staff. The grand prize winner received a Winnebago hike, which is a travel trailer, and the choice between a Ford truck or $40,000. We reviewed the independent financial results and the gambling records, which in our review appeared to be accurate and in compliance with WAC. In terms of the numbers, Special Olympics of Washington sold approximately $647,000 in tickets. They awarded $191,000 in prizes, and net proceeds to Special Olympics of Washington was approximately $182,000. I wanted to note that we did not receive any complaints regarding the enhanced raffle, and ultimately we confirmed that Special Olympics of Washington operated the enhanced raffle within the plan approved by the commission. I also wanted to note that there was an intervening Dream House raffle in May of this year. The licensee is still in the process of gathering records. However, I can report some preliminary results, namely that Special Olympics of Washington sold approximately $4 million in tickets. They awarded approximately $1 million in prizes, and net proceeds were just under $800,000. Turning to the proposed fall 2023 Dream Adventure Enhanced Raffle. If approved, the Enhanced Raffle would begin next week on August 15th, and the grand prize drawing will be conducted later this year on December 1st. The grand prize winner will have the choice between several vehicles or $50,000. And with that, I'd like to introduce Mary Doe and Mark Sine, the Chief Operating Officer and VP of Finance, respectively, of Special Olympics of Washington.
Thank you, Tony. Thank you, commissioners. My name is Mary Doe. I'm a Chief Operating Officer for Special Olympics Washington. And I think I just first and foremost really wanted to thank you all for allowing us to have the house raffle over the many years, as well as the second year, what we are proposing for the Dream Adventure raffle. This has truly allowed us to continue to rebuild post-pandemic and get athletes and families back on the fields where they have been longing to be. And so just really appreciate the support and an opportunity to apply for this opportunity again this year.
Hello, I'm Mark Sine. As was told, doing the financials and the numbers. We're excited about the opportunity to continue to have the second raffle. Post-pandemic, donations are way down for most charities throughout the country, and Washington's no different. This raffle helps us to continue the programming that we're trying to expand on and create more opportunities, especially in other parts of Washington that are underserviced. So every little piece we can do with these raffles has helped enhance our programs and help guide us towards reaching out to people who otherwise might not have the opportunity to participate in Special Olympics. So as Mary said, thank you for your consideration of these raffles and allowing us to continue this fundraising effort.
Great, thank you, everybody. Does any of the commissioners have any questions? Or
One. Nice to see you back. Hopefully in future times we'll see in person back again, but I know everybody's still kind of taking advantage certainly of the opportunities through virtual. I noticed, and the Winnebago, that was the Dream. What was the name of that raffle? Not Dream House.
The Dream Adventure raffle.
Dream Adventure.
Okay.
So when I was looking at kind of the results, I mean, it really looks like prizes are about 30% of the total. Benefits to Special Olympics is about 30%. Administration's around 40%, and I'm sure there's no hard and fix there. Remind me, is that pretty similar to what we've seen in all of the Dream House enhanced raffles? And can you tell me if that, I mean, is that a goal? Do you guys have specific goals when it comes to kind of that breakdown?
We do. The Dream House raffle operates on a different model in that there's a lot of postage and mailings and such, whereas the fall or Dream Adventure raffle is a lot more electronic with email and such. So we have lower cost on that. So there's about a 10 to 15% cost differential in expenses between the two. So the Dream House, the Dream Adventure raffle ends up being dollar for dollar a bit more profitable, but it can't be scaled in the same way as the house raffle. We definitely try and keep the payroll as a constant so that it's one or two people that do both of them. So that's one thing we're always trying to watch. The variables between either one is basically the cost, as in regulatory and or advertising and promotion. So we try and keep those within a certain stream. So for example, advertising is about 7 or 8% for the Dream Adventure raffle, and the house raffle is more like 17 to 20%, depending on categories of the type of advertising and such. So bottom line, yes, our goal is to keep the cost down and try and actually bring the house raffle cost more in line with what we're seeing with the Dream Adventure raffle by trying different mechanisms for advertising and such, and relying less on postage because the paper's expensive. Postage keeps going up and that kind of thing. So we're always looking for ways to kind of shave the cost of sales on both of these raffles.
Okay. Well, maybe report on that next year.
Sure.
Yeah. We're out.
Any other questions from commissioners? This you? I don't see any. Is there any public comments? Anybody? Anything in the chat? No. All right, very good. Do we have a motion?
Sure. Madam Chair, I move to approve the Special Olympics Washington to conduct a Dream Adventure raffle as presented by staff.
Second.
Okay, it's been moved and seconded. Is there any further discussion? All those in favor say aye.
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 Aye. All right, motion passes 5-0. At this time, 10:59 a.m., the Gambling Commission will be going into executive session to discuss current and potential agency litigation with legal counsel, including travel negotiations, and is expected to reconvene the meeting in 1 hour to continue the meeting.
Thank you so much. And
Thank
shout
you.
out to Agent Tony. He's a pleasure to work with. So you have a really wonderful group of people.
Thank you very much.
Thank you.
Okay.
Welcome back to the commission meeting. I'm going to go ahead and make sure we have everybody. I have Commissioner Patterson, Vice Chair Patterson here with me, Commissioner Sizemore, Commissioner Lawson, are you? I see Commissioner Ibsen there.
Present.
We have Commissioner Lawson. All right. And Senator Conway.
I'll forward the meeting maker back to me.
All right. Senator Foley. Okay, well, I believe we have a quorum, so we will go ahead and get started. We are now on tab 4, which is a default with Sue Chin. We have James Richardson, a staff attorney, here with us.
Hello. Good afternoon. For the record, James Richardson, legal manager. Just one default on the agenda today. That'll be Sue Chen, case number CR 2023-00239. Ms. Chen holds a cardroom employee license number 68-36334, authorizing public cardroom activity at the Roman Casino in Seattle, Washington. It is set to expire August 18th, 2023. The procedural history of this case finds that Chen was previously caught cheating at Riverside Casino in Tukwila, Washington on July 26, 2021, and was subsequently issued a notice of infraction. On January 17th, 2022, WSGC received a complaint from Roman Casino indicating that Chen had been suspended for 1 day for giving $950 in chips to another cardroom employee while she was off duty, resulting in a verbal warning. On February 3rd, 2023, WSGC received an email from the Roman Casino general manager detailing that Chen had been found trying to steal a $300 gaming chip, but dropped it on the floor while attempting to place it up her sleeve. The email included an incident report that detailed Chen's actions. When she was interviewed by WSGC special agents, Chen indicated that she had attempted to take a chip from the tray, but was unsuccessful. Chen further admitted to multiple instances of this behavior and indicated that she knew her actions were wrong. Charges were signed on June 12, 2023 by Assistant Director Gary Drumheller for Director Griffin while she was out of the office, and were issued on June 13, 2023, sent out by regular mail and received within 3 days. A response was required by July 10, 2023. The commission received no written response from Ms. Chen. However, she did call to discuss the situation with me on June 21, 2023, where she indicated she had no desire to defend the matter, admitted wrongdoing, and asked that this not impede her attempts to find suitable alternative employment. As a result of Ms. Chen's failure to take any action to defend her license, the commission may take final action to revoke said license. Ms. Chen cannot prove by clear and convincing evidence that she is qualified for licensure. As a result, staff now recommends that you sign the order in front of you, revoking Ms. Chen's license number 68-36334. If there are any questions, I'm happy to answer them.
Thank you. Any commissioners have any questions for? Seeing no questions, then do we have a motion?
I'll make a motion.
Sure.
I move to revoke Sue Chen's public card room employee license number 68-36334 as presented by staff.
I'll second that.
Okay, it's been moved and seconded. Any further discussion? All right, all those in favor say aye.
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 All right, motion passes 5-0. Thank you. Next up, we have tab 5, which is a petition to initiate rulemaking with Lisa McLean. Go, Lisa.
Good afternoon, Commissioners. For the record, Lisa McLean, Legislative and Policy Manager. Today, we're on tab 5, which is a petition that we received from Darren DeRoche of GameWorks Seattle. Okay, he has submitted a petition asking to increase the maximum wager for amusement games from $3.50 to $5. The last increase, he says, was over 10 years ago, sorry, when it was raised from 50 cents to $3.50. Given the fact that the cost of everything has increased and that the cost of prizes have risen dramatically, the petitioner believes that the cost per play should increase as well in order to offset the operator's costs. Moving down to policy considerations, in 1992, the maximum fee was set at 50 cents, and then it was debated in 1997, 2007, 2008, several times to increase wager limits. The discussion centered about the concern of increasing wager limits geared toward children. The commissioners finally did approve an increase on the wager limit from 50 cents to $3.50 that took effect in February 2011, where the petitioner and the discussion focused more on the costs, the operator's costs, and the operator's profits. According to the CPI inflation calculator, $3.50 in 2011 equals $4.75 today. Staff has reviewed statutes from about 24 states, and the majority have no wager limits, although some set a limit on prize value. Those that did have wager limits have limits ranging from $3 in Wyoming to $20 in New Jersey. Under the requirements of the APA, the Commission can decide to initiate rulemaking for further discussion or deny the petition in writing. I'm available for questions. I believe our subject matter expert, Sonia Dolson, is also available. And I think the petitioner may be here. I'm not entirely sure. He is aware of the fact that we're discussing this.
I have a question, Madam Chair.
Yes.
I have a question about the word wager in association with amusement games. And I'm not completely sure what these games are, but I don't know, when children put their money into a slot to play amusement games, do these games always have an unpredictable outcome? And yeah, and if not, I wonder why it's called a wager.
I can't necessarily answer why it's a wager. That's what it is. But it's
unpredictability, and
it's the amusement game is played for entertainment. Okay, and it's considered to require a material degree of skill, a little bit of skill, but the only merchandise prizes can be awarded. And if we think about this, I guess the best example is maybe a crane game.
yeah.
You know, you think about that, you put money in there and you pick a prize.
Well, there's an element of unpredictability there.
Yeah, by manipulating the.
But it just doesn't, these are games that children are playing.
And Commissioner, if
Yes.
I can address some of this, the term wager is used in the definition of amusement game. So this is the term of art that is used to refer to the amount that can be
Well, I
utilized.
can't argue with the term of art.
Okay, okay, but is the term
I
used
try.
in your statute? Okay.
It's just a side question. Thank you.
Senator Conley?
You muted, sir.
I have a question on amusement games. You know, the amusement games that I most see are the ones in the grocery stores, occasionally in other youth facilities. I've seen amusement games in miniature golf, for example. But I also know there's amusement games that are largely in big facilities. Chuck E. Cheese comes to mind here. So when we're looking at this amusement game issue, can you tell me what the types of games that we are really referring here to? Because some of the amusement games in Chuck E. Cheese are just shooting basketballs or something like that
Right.
too. So can you give me an idea of what we mean by amusement games here? Because I think the amusement games vary a lot.
I would ask for help from my director.
So there are 12 types of amusement games as outlined in rule. WAC 23013 chapter is where these amusement games are outlined. And so I'm not going to talk about specific games, but I'm just going to give you the groups that are outlined in the WAC. So group 1 is ball toss and kick amusement games. Group 2 is dart amusement games. 3 is hoop and ring toss. 4 is coin or token toss. Group 5 is hand-eye coordination. 6 is strength test amusement games. 7 are crane amusement games. 8 are penny fall games. 9 ball roll. 10 shooting amusement games. 11 cakewalk and fish pond amusement games. And group 12 electronic puzzle and pattern solving games. So is that
Answers the question. As I heard the list there, I could almost see them at the fairgrounds as I walk through a fairground. But I'm wondering, the wager limit on these games or the amount that you pay all vary considerably, right? Even though they're asking here us to raise the amount that they can possibly raise through the amusement game, they have the authority to charge whatever they want, right?
Yes, each operator can charge whatever they want, up to the maximum for groups 1 through 11 of $3.50.
And so, can the gambling commission tell me that is anyone ever at the maximum of $3.50?
We don't monitor that. I don't know.
Maybe the petitioner's here.
Thank you.
Thank you. Is the petitioner here? Darren De Roches, perhaps? Maybe I said that right?
I don't believe so.
All right, doesn't look like it. Commissioner Sizemore?
So I'm not really interested in increasing. I mean, part of the rationale is increase wager limit to $5, and then they can increase the price of or the value of prizes. And I mean, these are focused on kids. And as I think about everything in the electronics world gets less expensive rather than more expensive. You get more computing power for less money going forward. So I have to assume, unless there's anybody can refuted that, you know, the cost of the machines and all that stuff is not probably a driving factor here. So I'm really not interested in having these machines be at $5 so that prices can be more. One of the things that this agency and this commission's dealt with for a long time is, problem gambling, and certainly do not want to set up a precedent for kids to be comfortable wagering $5 in a whack to try to pick a ball up off a crane game or to accrue tickets at an establishment that has skee ball and shoot the star out and all those sorts of things. So it feels just not right to have kids feeling comfortable wagering $5 a time or whatever the activity is. I'm not really probably comfortable at $3.50, but that's the current rule. So for that reason, I am not supportive of initiating rulemaking on this.
So Commissioner Sizemore, would you, because the petitioner isn't here and there might be, I don't know, there might be more information that the petitioner could provide us with. I generally speaking, intuitively, I agree with you on this. But do you think we should allow one more opportunity for the petitioner to at least weigh in?
I don't need that.
I do. I feel like I have questions, or I don't know. I kind of want to know where they're coming from with this, but I also don't know how to make sure someone comes to me. I don't know that we can do that.
I believe the petitioner was notified of this action before you today, because we do have to, by Administrative Procedures Act,
you have 60 days from the date of receipt of a petition to approve or deny in writing. Generally, the petitioner themselves can agree to extend that time, which they have done in some cases, but I don't believe they have in this case.
And they were notified, and they even acknowledged the notification. So I was curious that I had asked them to reach out to Julie to get the details on how to join the meeting, and they did not do that. But they did acknowledge my email saying that it's going to be on the agenda.
I heard my colleagues say that he wasn't interested, and I'm not very interested in this either. However, if the petitioner has more information that we haven't heard today and has expressed any indication that they would provide us with that information, that would be something that I would be interested in hearing. But it doesn't sound like they've done that. They're not responding to us. So I kind of agree with, I think I agree with Bud with that information. This person you reached out to this person, they acknowledged that they had heard from us. You told them about this meeting, you gave them the opportunity to dial in, and none of that happened. So we have a lot to do here in this agency. Yeah.
Or so just want to clarify, you did ask for public comments?
Not yet.
Okay, thank you.
So getting ready to.
I'm done.
Gonna see if there's any more commissioner comments, questions. No? Okay. Any public comment on this? Nope. None in the chat, not seeing any. All right. Then do we have a motion?
I don't know if I didn't look, you acknowledged, or I move to deny the petition in writing, based on, the fact that this is, gaming for children in essence, and I guess air quotes maybe are appropriate there. And I don't see a need for an increase in wager limits and or prize limits for children. And I don't believe that an increase at this time in amusement games is warranted based on our responsibilities in the Gaming Act.
I'll second that, but I'm just wondering if this person were here, if they would tell us that the prizes are costing them a lot more, or if they would have any kind of a, I've seconded your motion, Bud, but I'm still wondering about that. I just want to put that out there.
Yeah, the petitioner does say that in this material that they submitted,
Yeah,
that the cost of prizes has gone up. But
right.
anyhow, it has been moved and seconded. Is there any further discussion? No? All right, then all in favor say aye.
Aye.
I,
Aye.
Aye.
Aye. Okay, next up, we have tab 6, petition to initiate rulemaking with Lisa McLean.
vote on this.
So here we have a
Maybe.
petition for a new rule submitted by Jonathan Schwartz of Enumclaw, Washington. He would like a new rule to allow children who are at least 10 years old to gamble for either fake money that can be used to purchase goods or no more than $100 in real money. He thinks it would be fun for children and allow them to learn why some of their parents are so addicted. And it would also give children some resources to apply things that they might want. The statute makes it unlawful for any person under the age of 18 to play in authorized gambling activities, except for bingo, raffles, and amusement games based on rules that are generated by our agency. And those rules are generally, if we want to sum up what they are, is adult supervision is necessary. So the petitioner's first notion of allowing individuals under 18 to gamble for fake money that can be used to purchase goods would represent an exchange for things of value, which would not be permitted legally under the definition of gambling. The second notion of suggesting that individuals should be under the age of 18 should be allowed to gamble for no more than $100 is gambling, would be contrary to the legislative intent and RCW. Also, allowing youth to take part in gambling activities once they've reached the age of 10 could actually add to problem gambling issues. So under the APA, you have 60 days to take action, either initiate rulemaking or deny the petition, and staff is recommending that you deny the petition because it's contrary to RCW 946.010, contrary to the age restrictions in 946.228, and has the potential to impact negatively on problem gambling among youth. Just to anticipate one question, I have reached out to the petitioner repeatedly and asked by email, by phone, and I have not received any response from that person. So I don't know if, I'm pretty sure they're not here right now. And I'm not sure that they are interested in defending this.
Thank you, Lisa. Any questions for Lisa?
What a tremendous waste of staff time.
Is the petitioner here, Jonathan Schwartz? Any public comments? Anything in the chat?
No.
I don't think I need to. Okay. I'm not seeing any. Is there a motion?
Who wants the privilege?
Go ahead.
Madam Chair, I move to deny the petition in writing. And the reason why is because this petition is contrary to legislative intent as stated in RCW 9.46.228. That's it.
We have a second?
Second.
All right, it's been moved and seconded. Any further discussion? All right, all those in favor say aye.
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 Okay, we'll now move to tab 7, 2024 agency request legislation with Lisa McLean.
Okay. Moving to legislation. After further discussion within the commission and with our AAGs, we are seeking to withdraw the suggested idea for agency request legislation that we presented in July. The Attorney General recently reissued an informal opinion on this topic, and we think that we can continue to work closely with the AG's Consumer Protection Division to enforce any complaints that we receive on this. So we would like to withdraw the proposed ARL topic unless you would want us to stick with it and continue forward with it. And then I think if that's okay, I'd ask you if there are any other topics that you'd like us to look into for 2024.
Anybody have any questions for Lisa? Any other? No?
I guess a comment. So, you know, the proposal that staff had certainly was, you know, an effort for clarification and to ultimately reduce staff time down the road with that clarity. The fact that things have changed in the last month or few weeks, and there appears to be increased attention to consumer protection related to those issues. I think I'm certainly comfortable with not going forward with that as agency request legislation. And, you know, just based on the last several years of the legislature as they convene, it seems like we end up with a pretty handful of issues that we end up having to weigh in on anyway. So I'm not sure why this year would be any different than those years. I think we're going to have a strong presence on the Hill as we have been doing, and not bringing an agency request bill, you know, I don't think changes that. I think it still has us on the Hill, providing, you know, more information to legislators, as well as improving our relationships on the Hill. So I'm fine with not having a agency request legislation this year.
All right. Any other comments, concerns? You're muted, Senator.
My thought is I'm hoping that we continue our work with the various committees in the House and Senate in terms of some general reports from the Gambling Commission on what's been going on. I think that would be valuable. I also believe that, you know, as we see some change, we're seeing changes in the structure of training police officers in our state with the development of more regional training centers. And I presume that will also impact our people, enforcement people as well. So I'm hoping that we recognize that there probably will be some action in Olympia around some issues that will be of importance to us. So I think it makes sense not to move forward with the bill. I think I expressed that at the last meeting, but I do believe that we should continue to make sure that the Gambling Commission activities are brought before the committees of the legislature. Thank you. I think that's part of our overall purpose anyway. So thank you.
Thank you. All right, so
Thank you, and I hear all that you're saying. I think we will be actively up on the Hill. Already, as the director said earlier, we're already prepping for a what we call Gambling 101 session for legislators before the session starts. So that's going to be our first thing, but also we'll be up on the Hill. But one thing I would point out, Chair, is since we're not going to move ahead, then there's no need for the special meeting that we sort of penciled into our calendars for September 12th, right?
Okay.
Thank you.
Yeah, so the September 12th meeting will be canceled since there's no agency request legislation pending. And so we will move on to tab 8, which is problem and responsible gambling. Let's hand it over to Executive Director.
Thank you. And we have Roxanne Waldron from the Healthcare Authority. She is the program manager for the state's problem gambling program. And so I've kind of invited her to speak on this topic with me today. And so I'm glad that she's here to help address this. So, so this is before you a few topics regarding problem gambling and responsible gaming, and put them all together so that we could just have a conversation. The first topic being, as I indicated earlier, the National Council of Legislators from Gambling States did adopt a resolution. 16 items were outlined and in this resolution, and in taking a look at it, both in this memo with the lens of what is the Washington State Gambling Commission already doing for each of these topics, and or are these strategies maybe that the Gambling Commission go beyond of what the mission of the Gambling Commission is doing? Are there strategies that were addressed as a result of the Problem Gambling Task Force's recommendations? And so as a whole, out of the 16, I was able to identify that we're doing a pretty good job, I think, in addressing these matters that were outlined by, I'll just say, the legislators. So with those 4, though, I have since talked to Roxanne, and she has pointed out that the Healthcare Authority has some actions that they're taking, and a few of the ones that in the 4 that we haven't addressed. So with that, unless there are any questions, I've listed in there a column of what we're currently doing to address the resolution. If you would like to just focus on the 4 that we are not, that we don't have a strategy identified for, and or that we're not currently doing something, we certainly can talk about that, or we can approach this in any manner you wish. I can just talk about the 4 that we're not addressing at this time, and I think that Roxanne has a few points that she passed along to me. So one is number 7, suggests that the states and operators coordinate gambling exclusion lists to prevent people with gambling problems and others on exclusion lists from problematic play in other states. So that is one item. Then number 9 is calls for responsible gambling. Calls for responsible gaming and problem gambling policies and insurance coverage for all employees of gaming licensees. So Roxanne pointed out that insurance coverage isn't necessary to receive problem gambling treatment in the state. That is something that the state program is designed to take care of. And so while we have not addressed this, nor is it obviously addressed as a strategy for the Problem Gambling Task Force, this is certainly something that is already addressed within the program that the state is funding at this time. So I didn't add a column for, what is the state problem gambling program doing? And Roxanne, may I invite you to a microphone, please, if you would like to speak more about the program. Thank you. Oh, yes. Sorry.
Thank you, Director Griffin. And I'm Roxanne Waldron. I'm the State Problem Gambling Program Manager, and I'm within the Healthcare Authority. The program is within the Healthcare Authority. I want to thank you, Chair and Vice Chair, for allowing me to speak, and Commissioners. So do you want me to speak to a couple of those items then?
Yeah, we can just talk about the next one was number 11. We'll just go through the other two, and then you can, if you want to bounce back to the ones that you've identified some work in, that would be good. Number 11 is the other one, calls for development of state or jurisdictional advertising guidelines to ensure marketing is only targeted to those who are of legal age to gamble, follow standards to not offer content, themes, and promotions that have special appeal to those consumers most at risk for gambling problems, and to ensure that those programs ensure that there are programs that audit and monitor the content of third-party marketing affiliates. And then lastly, number 15, which emphasizes the need to include access to anonymized player data, research components, and funding for responsible gaming and problem gambling policies to gauge trends, program efficacy, adapt to current conditions, and to expand evidence-based best practices and new prevention and treatment techniques. So I will, let you please speak to how the program, if the state program, is working on any of those to help fill any of those gaps.
Sure.
Thank you.
So the first one was, I think, 7. It's not numbered on, 7, yes. Suggests that states and operators coordinate gambling exclusion lists to prevent people with gambling problems and others on exclusion lists from problematic play in other states. I would say that since we do have a statewide voluntary self-exclusion program, this would be beyond the scope of anything that HCA would be looking at. So I can't really speak to that one. And I think we talked about how that might be a difficult thing to do.
Right.
But that would be beyond what HCA would be doing.
Harrison's a question about that.
So from my perspective, with regard to self-exclusion, the biggest challenge we have is that we are not coordinating with the tribes.
Right.
And they have their own programs for self-exclusion, and each one of them have a little bit different, what do you call it?
They have their own programs.
They have their own program
Right.
for self-exclusion. Some might, they have different time limits and everything, a lot of differences. So the challenge would be for the state to be able to coordinate with every single tribe in the state of Washington that has a program like that. That's hard to do. So, Roxanne, one of the things I was wondering is, I hopefully someday that'll happen, right? That's what I'm thinking. But in the meantime, I'm wondering why we couldn't talk to the card rooms about them providing their information to the tribes. And I understand that each tribe has a different program, but when people choose to self-exclude, how about if we tell them this information will be shared with the tribes, and that you agree that each individual program that each individual tribe has will be applicable to you. So that in a way they're giving permission for that to be shared. And I think that I might be naive, but it might be a good first step to creating an opportunity for that information to be shared. That's just what I
So I'm going to defer to Gambling Commission staff and director about that.
Thank you. So I want to back up for a second just to point out that the tribes have, it's my understanding, have had long-standing programs in terms of self-exclusion.
Mm-hmm.
So we are just coming to this, we've just developed and stood up our program in 2022, while the tribes have had their individual programs for a number of years. And each tribe within their sovereignty has set up their own ordinances and regulations and programs, obviously. So we have had tribes reach out to us and inquire about, because I don't want to leave the impression that, the tribes are not coming to us or we're not engaging the tribes at all in any capacity, just for the record. So, so we have had that communication. And the challenge is because, as you indicated, because we have different term limits and whether people can get on or off the list and what that looks like, and that communication and what an ordinance or requirement for the tribal program is compared to ours, there are challenges. Now, getting to what you are proposing, Vice Chair, what I believe I heard you say is that we, the state, as anybody who would come to sign up for the state program, right now says any tribe, I believe it uses the language out of RCW 946.071 about opting in, that if a tribe opts in. So we haven't had a tribe opt into this, join the state in their program. So I would have to look to our attorney to ask, if we didn't have a tribe opt in, and that is the form language that individuals are signing saying, hey, this will apply to any tribe that signs to opt in, how we can share that information with tribal entities and say they may or may not enforce. Okay, so I'm not.
You're not resonating with me.
Okay. Sorry. If you could repeat.
You just repeated a lot of things that I think I just said.
Okay.
This is an idea. It's raw.
Okay.
Okay. So I'm throwing it out there that if I had a gambling addiction and I wanted to self-exclude, I would want to prevent myself from going to any casino in the state of Washington. And we do not have a way by which people can do that. They can self-exclude out of card rooms, but they can't automatically self-exclude out of tribal casinos. What if we had a long conversation with the tribes to float this idea to see if it made sense for card rooms to share the information they have about people who want to opt out, so that the tribes could be aware of who those people were, and at the same time that we give those people with gambling addictions the ability to legally sign off on whatever the tribe's individual rules and regulations are associated with their self-exclusion program. It's a raw idea. It's kind of turning things, making things, looking at it in a backwards way. Instead of inviting the tribes in, which we should continue to do, it's like instead suggesting we just give our information to the tribes. And like I said, I know it's a raw idea, but I think that it's worth, I mean, if unless there's something fatally wrong with that, I think it might be worth considering.
And so, Vice Chair, if I can just clarify, you're asking if you could share confidential information about those with problem gambling.
I'm asking that
with
the addicted
without an agreement.
I'm asking that we work with the tribes on this raw idea, and I'm asking that the addicted gambler be asked at the time that they're signing up to self-exclude to give that confidential information, to give permission to give that confidential information to the tribes. We wouldn't do that without their permission. But if you were a gambling addict and you lived in like my neck of the woods and you couldn't go to the Silver Dollar Casino, what would you do? You would drive over to Muckleshoot. And I don't think the Muckleshoots want that person there. So it kind of, and I think the addicted gambler in that moment of lucidity would probably want to self-exclude from Muckleshoot as well. That's my take on it. So does it make sense to talk to the tribes about this idea and then get your legal opinion as to whether or not the addicted gambler could give permission to share that information with the tribes?
We can explore it.
That's all I want to hear.
We'll report back.
I think I saw when you were first speaking, Senator Conway and Commissioner Lawson both raised their hands. So let's hear from Senator Conway. You were first.
Well, I'm just responding. Julie's brought another issue here, and it's an important issue, and I'm with our healthcare authority person here. I think we can. To me, my question though for her was that why, Roxanne? My question for you is why would we not? I know the statewide group here made this recommendation, but why would we not be having conversations with some of our neighboring states and in the case of British Columbia, them about the issues of this? I know that the self-exclusion list, I'm not sure where Oregon even has the self-exclusion list. I'm not sure what the situation is in British Columbia either. But I do believe that, Roxanne, we should at least understand how our what I call partner states are doing on these issues so that we might explore more coordination with them. And I guess that's a question for you, Roxanne, more than anyone, that I think the idea here of a national self-exclusion list is very ambitious, obviously. But I do believe that there is an opportunity here for us to explore conversations with some of our neighbors about this issue.
So my response, thank you, Senator, for the question. My response is twofold. One is that HCA, Division of Behavioral Health and Recovery, we're focused on prevention, recovery, treatment. We don't administer the VEP program, the voluntary self-exclusion program. On the other hand, though, as you know, having been a sponsor of that bill with SB 5634 that did pass, there is an advisory council that is being created and that will start meeting in the fall. And it is tasked at looking at recommendations that came out of the Problem Gambling Task Force report. And one of those recommendations was around the VEP and establishing that. So I believe that the work that we had initially said we would do around that has been completed, but I don't see why that couldn't be a topic within that advisory council.
Great, I agree. And keep in mind, our tribal partners are still part of that group as well, right?
Yes, we'll be inviting a tribal representative. Yeah.
Yeah. So in essence, Julie, I'm just talking with you here as well about your idea that we do have an instrument for pursuing that. Perhaps the issue of my own sense of this too is that possibly some of this is going on, that there are communications going on self-exclusion with the tribes. I know in my conversations with them, they always spoke that most of this is a geographic issue as well. In other words, when you're excluding yourself from gambling activities, you're going to be working with certain tribes in your immediate area on those issues. So my own sense of this is perhaps we do not have enough information on this, on what the tribes are doing in terms of working with some of their partners in their respective communities. So thank you.
Mr. Lawson?
Thank you. Let me figure out how to take my hand down. So I think I see several things here. One is the recommendation number 7 is not specific as to whether we're talking about voluntary self-exclusion or involuntary exclusion. And I note that we have voluntary self-exclusion in Washington state that will exclude an individual from any Washington state licensed card rooms, and according to the Washington State Gambling Commission website, will actually even exclude that individual, voluntarily self-exclude that individual from certain tribal casinos. It says participating tribal casinos. So again, this already sort of exists to a certain extent, but I also note that that's not exactly what the resolution says, or at least not what is in the materials here. So the resolution suggests that states and operators coordinate gambling lists amongst states. It doesn't talk about tribal operators. And so in line with what Senator Conway said earlier, I think what we need to do is look at what we're doing to coordinate with other states before we start looking to our tribal partners and requiring that we all share exclusion lists amongst one another.
Okay. Just a point of personal privilege. I never use the word require. I just want to make that clear for the record. I use the words explore, work with, examine. I never once used the word require, and I'm not interested in requiring tribes to do anything here. I think that it would be wonderful if we had a way to communicate more effectively so that when people figure out that they need to self-exclude and they've come to terms with the fact that they have a problem, that they could do it holistically, is what I'm hoping for. So for the record, I just wanted to say that.
Okay, so thank you. We will take both of those into consideration. One thing that we'll have to take a look at, certainly beyond this discussion that we're having today, is 94607-1, which is the statute authorizing the self-exclusion program for the state, does have specific limitations on what the personal information that's collected, stored, and accessed for the self-exclusion program can be used for. It may only be used for the administration of the self-exclusion program and may not be disseminated for any purpose other than the administration of the self-exclusion program. So we will have to have further communication with our AAGs to see if that would need to be changed or not. But in the meantime, we certainly can be reaching out to British Columbia, as indicated, Senator, as well as our surrounding states, Oregon and Idaho, and see if they even have one, et cetera. So we can start doing that research. Thank you.
And, you know, next year when this committee gets rolling, Senator Conway, you'll probably be involved with the committee. I don't know if you will or not.
Well, I don't think we mandated membership on that committee, so
Okay.
I'm hoping what we do have are interested parties that Roxanne will reach out to be engaged in this continual conversation on implementing some of the recommendations of the Problem Gambling Task Force, as well as looking at other issues like the one we're having here today. So Roxanne has that obligation, and I'm just hoping that that's how we pursue. But Roxanne, I have all trust in you as well. So thank you.
Thank you. Although it's not specified in the bill that was signed into law, I anticipate that the Gambling Commission would like periodic updates on how that work is going throughout the year. And then that would be an opportunity to bring forth more information as well.
Okay, yes, so then we have number 9.
Yes, so number 9 is calls for responsible gaming and problem gambling policies and insurance coverage for all employees of gaming licensees. So the responsible gaming piece, that is already in place with the VEP, the training for commercial gambling locations. And then the insurance piece, as Director Griffin our state problem gambling program already is the payer of last resort, which means it is available, and it's a low barrier program to anyone in the state, family members and or individuals who are negatively impacted by problem gambling disorder. So that is always there, and that's a treatment reimbursement program that is funded through the business and occupation tax and the contributions from the commercial gambling, horse racing, and the lottery, as you know. The other exciting thing that is happening is that HCA has already submitted to the Centers for Medicare and Medicaid Services a request to add problem gambling assessment and treatment into the state Medicaid plan. We will likely hear about that sometime in early to mid-October. And if that is approved, and there hasn't been any pushback thus far, as I understand it, that we are working toward implementation on January 1st, 2024. So we're talking about coding and how we'll notify people. And so that will be very exciting because that will cover all Apple Health eligible clients. So, and then we will continue to operate the program. And so that will essentially, anybody who is Medicaid eligible will be asked to go through Apple Health, and that will sort of free up some money also in our state problem gambling program. So going back to this particular item, I would say that employees are already eligible, as is anyone else who is seeking services and does not have private insurance, cannot afford to pay out of pocket, or doesn't have adequate insurance through another means to get assessment and treatment for problem gambling.
Very good. Any other questions? So glad to hear that the state program has addressed that issue. And then resolution number, and then we have resolution number 11 having to deal with advertisement. That is certainly something that I don't know that the state program has any requirements, but that is certainly something that commissioners could initiate rulemaking or ask staff to do agency request legislation on.
Could I make a comment about that one as well? And I also want to comment on number 10 briefly. The National Council on Problem Gambling is working with Evergreen Council and other councils across the country to implement one number, the 1-800-GAMBLER, and that is in the implementation phase right now. What will happen there is, if people call it theoretically, they will be transferred then to the state helpline, or if they don't have one in their state, they will be assisted. So that's in progress. That's a work in progress.
It's already rolled out.
It's already rolled out.
It's
okay. It's already rolled out. Okay. Yeah. So that's wonderful news. That is an item that is happening. Number 11, what I would say about that, this is the consumer protection, as I read it, consumer protection piece. And there is a consumer protection recommendation and strategies that are in the problem gambling task force report. So that will be something that will be discussed by the advisory council going forward. And I think you are right, it might result in perhaps future rulemaking.
Yes.
And maybe other stuff.
We'll leave it to the commissioners. Yes.
And then you had asked about 13, I think, which is recommends integrating problem gambling services and screening into other substance use disorder, mental health, and or behavioral health services to identify, reduce, and prevent problem gambling. This, and I know, Director, that you had said that you had specifically commented on training around that. So that will be an ongoing piece. But I would say that the integration of problem gambling screening and services is actually one of the big pieces of work that HCA is taking on. And as of 7/1/2023 and increasing next year, we have increased funding to do that work. And so I'll be speaking in the future about how we're going to be implementing additional screening through a grants program. And then in terms of the other services, I'm working very strongly with the prevention unit at HCA to integrate our services, and also with the Evergreen Council on Problem Gambling to increase the amount of prevention messaging. And then in terms of how to integrate into treatment and recovery, that's an ongoing conversation that's going to be going on for years, and we'll be working on that.
Very good. Thank you.
Is that it?
And then we have number 15, which we're not at. We don't collect player data at this point, but I believe you indicated that one of your 5-year goals was to track treatment.
Yes, so the way I read this, actually, number 15 seems to me to be have two parts. One is to look at data that's coming in from gambling, and the other is to look at how effective is treatment? And so the looking at the gambling data, that is not something obviously HCA is going to do. And I think we talked about this could be a big barrier in our state. But the second part about evaluating the efficacy, that is what part of the funding, the additional funding will be doing program monitoring and evaluation going forward. So that is that we will definitely be looking at that, and we will likely run future problem gambling prevalence studies to continue to identify where the increases are in gambling and problems.
And that potentially with those studies, that's historically how we have approached finding out where program treatment levels, efficacy of existing programs, trends, et cetera, rather than accessing the player data portions of that, because that is just historically not something that, of course, everything, I guess, we could have a rule or a law change.
So the other thing I would say is that when you and I talked about this whole list, there are things that I think could be added to the what are we doing now and clarified. And so I'm happy to work with you on that, give you my feedback if it's helpful.
Well, and maybe that could be something that we could address as part of the advisory, because I think this does go beyond just the Gambling Commission and or HCA. So yeah, I think it would be something that collectively it would be interesting to address. Great. Thank you. Unless, and Chair, anything else in regards to this topic for discussion?
I don't think so. Is anyone? Thank you.
I just have one question for Roxanne, as long as she's there. Roxanne?
Yes.
What is the game plan in terms of implementing the advisory committee group here? Have you sat down and figured out when that will happen?
Yes, I have two new committees that are starting up. One will be the advisory council that is mandated in the law that was passed. And I have been reaching out to representatives based on the list that was in the law. And there are a couple spots that are not yet filled. So I'll be continuing that. My goal is to have that start meeting by October 1st. The other one is a problem gambling prevention work group, and that's not mandated in there, but it is going to help us establish our ongoing prevention plan, and that will eventually be entered into the statewide 5-year prevention plan. And that will also start in the fall.
Thank you.
Yeah.
Well, and that's brings up the next topic of the memo, which is the advisory committee as outlined in Senate Bill. I'll just skip all the engrossed second substitutes in the Bill 5634 piece, and from here forward we'll just be called Senate Bill. We'll just call it Senate Bill for the purposes of this discussion. But it does that Senate Bill did establish an ongoing advisory committee to be facilitated by HCA to, and this is straight from the Senate Bill, hold quarterly meetings, track progress on the recommendations of the task force's final report, which was out in December of 2022, provide advice feedback on state problem gambling program as requested by HCA, and discuss emerging issues related to problem gambling and identify possible strategies for improvement. We, the Gambling Commission, are one of many that are listed in the bill members to provide a representative, such as, in addition to us, lottery, horse racing, obviously HCA, tribal gaming industry, gaming counselor, the Gambling Counselor Certification Committee, maybe the whole committee, nonprofit gambling organization, the recovery community, and including one with lived experience in problem gambling, and then a representative of an established business primarily engaged in the selling of food or drink for consumption on premises that offers punchboard, pull tabs, and social card games as a commercial stimulant. So with that, just wanted to let you know that I had anticipated appointing a staff representative. I'll probably be attending either with that person or myself first meeting, and then as my memo indicates, be happy to report back on a quarterly basis after that, yearly, not at all, up to you. Look for guidance, but at this point, that was the plan and approach that I intended to take. And I don't know, I'll leave the floor open to you if you'd like to share, since this is your committee that you are leading then under the Senate bill.
Yeah, I think you've stated it clearly, and it will not be the heavy lift that the Problem Gambling Task Force was. So if there are, any of the commissioners that would like to participate as well, and in addition to staff, that would be wonderful. You are very welcome. I know you have a lot on your plate, so it's not an expectation, but it would be a wonderful addition.
I have a question about that.
Yes.
So if we always have one staff person, would it be appropriate, inappropriate, for a commissioner to come just every once in a while? Maybe they can't make it to all the meetings. Would you be okay if they just came to one? As long as there was always a staff representative, just so maybe other commissioners could go. Yeah, things are going.
I personally don't see a problem with that. One of the first tasks of this group, as I see it, will be I will prepare a draft charter to bring, and we'll just be able to discuss. That might be one of the items that we want to address on there, and won't solely be up to me. I'll be the facilitator, but yeah. So does that answer your question?
Yeah, I think so. I think
it would be
you
great.
don't want a bunch of people just in and out of your meetings all the time. So I'm trying to figure out the best way. I don't know if a commissioner can always make it. I think we'll always have a staff member, but it would be nice if a commissioner could. So maybe just something to keep in mind as things start.
And I would also say maybe we can talk about also how a person from the descriptive for the commercial venue, how to reach out for someone for that position. So thank you. Anything else?
Are there any other policymakers on the list of people who will be attending?
It's not required on there.
Okay.
Yeah, I think you listed most of the people that are required
I
to
pulled
be
it straight
there.
from the RCW.
Yeah.
Okay.
So I use the language from the RCW.
Yeah.
And yeah, because the RCW does not indicate policy recommendations, reports, feedback. This is just like as it's called, advisory committee for advice and feedback as requested from HCA, tracking progress from this final report, and discussing emerging issues and identify possible strategies for improvement. Can we take it one step further? That's up to HCA.
Well, I will just say that my intention is to share information and move forward. So, yeah.
I've having helped draft this language, it is an open-ended situation. I know that originally there was an idea of putting together a formal advisory council, and to me that was somewhat not, we were ahead of ourselves. This idea of this advisory committee really is trying to continue the work of the task force and to ensure that we're fulfilling the recommendations. And I think, Roxanne, I hope that your attitude about it is correct. People who are interested should come because it's a critical issue, and hopefully it'll attract even some of my colleagues from the legislature as well.
Thank you. Appreciate your time today.
Thank you. Are there any other comments regarding this? Do you have anything else?
No, thank you. And unless you have any other thoughts, direction. Thank you.
Is there any public comment? Nope. Nothing in the chat. Okay.
I put together a little motion, Madam Chair. I move that the Gambling Commission endorse the National Council of Legislators and Gaming States Responsible Gaming Resolution and direct staff to present this resolution to the Problem Gambling Advisory Committee, which will begin meeting soon, and keep these issues in the forefront of their work. And then I had a little amendment to offer because we had this discussion about working with tribes on self-exclusion. And in number 7, and this resolution was put together by the other states in the country, almost all of them do not have tribal casinos, or if they do, there's not many compared to our state. So they didn't include tribes in this recommendation number 7 to coordinate. So, recommendation to coordinate with other states. I would suggest that we talk about coordinating not only with other states, but also with our tribal partners in the state of Washington.
We have a motion on the table. Is there a second?
Can I get someone to read back what the full motion is?
I move that the Gambling Commission endorse the National Council of Legislators in Gaming States, that's the name of the organization, their responsible gaming resolution, and direct staff to present this resolution to the Problem Gambling Advisory Committee and keep it in the forefront of their work. In addition, I advise that we not only coordinate with other states on issues related to self-exclusion, but we also, in the context of this committee, coordinate with our tribal partners.
So I might just suggest adding one word to that at this point. And that would be that you're exploring coordinating
Yes.
with your tribal partners and other states. And that would be my one suggestion.
As gently as we need to proceed.
Okay. We have a motion. I will second it. Is there any further discussion?
I could support the motion if it was one on coordinating with other states and separately on tribes, but I think bundling it all together, I can't support the motion.
I would accept a friendly amendment from you, Commissioner Lawson. I mean,
sure. So, and I don't have all of the language in front of me, but the amendment would be to separate the two items so that it would be a motion to explore coordinating with other states pursuant to the Nickel-G's resolution. And then I would propose there be a second motion made to explore coordinating with tribes on self-exclusion. But I believe that is already happening. So I'm not sure that the second part is necessary.
So what if we have this Nickel-G's 1 through 16 that was adopted? Can we add a number 17 that includes exploring with the tribes? So, because number 7 already says we'll partner with our states. So then it would just be, and that's part of 1 through 16. So we added number 17.
Yeah, 17 wasn't included in the Nickel-G's resolution. So I think we need to either adopt the Nickel-G's resolution in full and add our own separate resolution to coordinate with tribes, or not, basically.
can I reiterate? Oh, excuse me, go ahead.
And I, I look at it that way because number one, yes, I understand that not all states have tribal gaming, but most states have some level of tribal gaming. And 2, I know that we are already working with our tribal partners, at least if the information that we are putting out on our website is to be believed, then we are already working with our tribal partners on self-exclusion and coordination of any self-exclusion lists.
So to make everyone happy, I will withdraw my my motion at this time. And I would like to offer a new motion with an amendment. So my new motion would be, I move that the Gambling Commission endorse the National Council of Legislators in Gaming States Responsible Gaming Resolution and direct staff to present this resolution to the Problem Gambling Advisory Committee and keep it and ask them to keep it in the forefront of their work. That is my motion. And then I have an amendment, and the amendment would say that the Washington State Gambling Commission adds to the list a recommendation of their own, and that would be the language that Commissioner Lawson just provided on coordinating with tribes. So that's my new motion. Tribes are such an important partner for the state of Washington, much more so than any other state, in my opinion, in the country, based on what I've learned. It's extremely important that we mention how great this need is to work with them on these things. And so hopefully you all will accept that.
We have a motion.
Sorry, to be clear, so now there's a motion to accept the Nickel-G's resolution and present it to, I don't want to say the task force because I know that that's not correct.
The advisory committee.
The advisory committee. And then is there with an amendment to the resolution? Because I don't see how we can go and amend the Nickel-G's resolution.
We can amend
on our own.
We can amend. We're not amending Nickel-G's resolution. We are amending what it is that we are directing staff to present to the Problem Gambling Advisory Committee, and we are amending what it is that we are asking be kept in the forefront of their work.
So we're asking that they present the Nickel-G's resolution to the advisory committee and keep that in the forefront of their work. And then we're asking staff to also what with tribes?
We are asking that the states coordinate gambling exclusion lists to prevent people with gambling problems and others on exclusion lists from problematic play with our tribal partners. That we work with our tribal partners on this issue.
I still see that as a second, I guess, a secondary recommendation, but I think in that regard, I can support it. I just, we can't go back and tie tribal partners to the Nickel-G's resolution because they weren't included in the Nickel-G's resolution.
No,
but if
they
we
weren't.
want to, right?
They weren't.
But if we want to direct staff to explore,
including them,
explore working with tribes.
Okay, working with.
They can't be included in the Nickel-G's resolution because
no,
that was already
included in the work.
Right. Well, no, working with tribes, right, in the work. But I think that they will be. I mean, looking at the legislation, there is a tribal representative who will be there.
That's why I think it's really important to say that. I mean, just so that they know that we are aware of this issue and that we're supporting it and that we're hoping that they will, through the years, I imagine this committee is going to be around for quite a while. We'll have these conversations with the tribes and we'll move forward in whichever way works best for all.
So
that's my intent, Commissioner Lawson. Yeah.
And
If I might, I don't want to interrupt the discussion.
No.
If I might suggest some things just for clarity of what I'm hearing you want to move forward. It sounds to me like there might be two motions here that you're looking to make. One would be to endorse the Nickelbees resolution and ask to present it to the advisory committee. And then the second is that the Gambling Commission is also asking staff is also endorsing its work, all right, its current work with the tribes in the important work of self-exclusion and problem gambling, and asking staff to also recommend that work to the advisory committee. Or something along those lines. It's sort of the two prongs, if I'm understanding.
Yeah,
Okay.
yeah, exactly.
I think we get to the same place that way.
I
What
think
do you
it would be
think?
a lot clean. Yeah, I think it would be a lot cleaner if we had two separate resolutions.
So I withdraw my motion and I present the following motion for consideration. I move that the Gambling Commission endorse the National Council of Legislators and Gaming States Responsible Gaming Resolution and direct staff to present this resolution to the Problem Gambling Advisory Committee and keep it and ask them to keep it in the forefront of their work.
I'll second that.
Okay, it's been moved and seconded. Any further discussion? All those in favor say aye.
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 Okay,
Mr. Lawson, would you like to make the next motion so that you know what you're comfortable with?
I would like to make a motion that commission staff, that states that the commission supports the commission staff's current work with tribal partners in the area of self-exclusion and supports staff's working with the advisory committee on the issue.
I don't, discussion. Commissioner Lawson, I'm interested in the advisory committee doing much more than what they are currently doing. So when you say the current work, I want them to be thinking outside of the box. Like, for instance, like I said, I came up with this raw idea that maybe the card rooms could be sharing their self-exclusion information with the tribes. I want the advisory committee to hash through that stuff. And that's not current. That's not going on currently. So I would like to see us recommend something that is much more progressive than that.
Well, then perhaps what we should do is table the remainder of this discussion and put it on the next meeting so that we can look at what's been proposed in the bill to the legislature and what the commission is already doing, or the commission staff is already doing in this arena with tribes. Again, I know that our website says that we have participating tribal gaming facilities with our self-exclusion program. And so I guess before we go making a resolution or passing a resolution, directing either our staff or proposing to the advisory committee that they look at a particular issue, I don't want it to be duplicative of other efforts.
Supported the first one, thinking of the second one.
Okay, so we have a motion on the floor, Lee.
And just as a point of order, I don't believe there's been a second.
Right. Is there a second? Hearing none, I think the motion is done. There, right?
I have a motion to make, Madam Chair.
Okay.
I move that the Gambling Commission direct our staff to suggest to the Problem Gambling Advisory Committee that their work include discussions regarding the coordination of gambling exclusion lists to prevent people with gambling problems and others on exclusion lists from problematic play in Washington State tribal casinos.
Okay, so you're just directing the staff to go forward and do further.
Well, I'm actually, what I really want to say, yes, the Gambling Commission is asking staff to work with the advisory committee on that issue. Could I speak to that amendment, Madam Chair? So the state of Washington is very unique in that we have more tribal casinos than any other state in the entire nation. And it requires a great deal of coordination and discussion and collaboration in order for us to accomplish goals that will reach the entire state of Washington. And this is a perfect example of one that just cries out for coordination, because you can self-exclude from a card room and drive down the road, and there's a great big tribal casino that, if you have a gambling addiction, is very titillating that you can go into. And you can't self-exclude from those tribal casinos unless you go to each one individually. And I think that there's a lot of work that has to be done to try to figure out how our tribes and our state can work together to develop a comprehensive self-exclusion program. And I think it's imperative upon the Gambling Commission to make it clear that we think that that needs to happen in the work in the years ahead of us. So that's the point of the amendment. From my point of view, that's what I had. That's what my intention is.
Yeah, no, I am almost there with your amendment. If I can just see the words on a page. There's one change I would like to suggest, but I do want to go back. So this has been said more than once now, so I Googled it. We don't have the most tribal casinos of any state in the United States. California has more than we do, probably has actually double. They have 69 casinos and we have 35. So we're not the only state grappling with this. But I think
Most tribes.
the only, and those are tribal casinos.
I meant to say the most tribes, not the most casinos.
We probably don't even have the most tribes. California might actually have more tribes simply because they have very many small rancherias that are there.
I stand corrected. Second.
So, if there's someone who could read back Commissioner Patterson's motion for me, I could probably put my finger on the one suggested change I would like to make. Is that possible?
Commissioner Patterson has to do.
I'll restate it if someone could write it down this time.
I wrote it down. I have it written down.
Do you have it written down?
I was trying to write very fast. Washington State Gambling Commission will direct staff to suggest to the advisory committee that their work be included in coordination. Oh, nope, I didn't get it.
Okay, no, but you
not even close.
You got me enough. Okay, because the last part right where you left off was right where I tripped up. So it should be, I would suggest it be suggest to the advisory committee that they work with tribal partners on coordination of self-exclusion lists, or explore working with tribal partners on self-exclusion lists. But I think there was just a tick in the way it was worded before, where it made it sound as if the advisory committee had complete jurisdiction over tribes, which does not accurately reflect the relationship of the state and tribes. So there's my suggested amendment. Julie, did you get that down?
I have.
You do?
Yeah.
Suggest. So just one thing to note is that Senate Bill 5634 forms this advisory committee, and I'll just reiterate.
Go ahead.
What the advisory committee's responsibilities are, and that is to track progress on the recommendations of the task force, final report, provide advice and feedback on the state gambling program as requested by HCA, and to discuss emerging issues related to problem gambling and identify, so they can discuss it. So are you asking that the advisory committee also get to a point of,
What is the
I'll
language?
listen to the motion. I guess, yes, I guess I need to listen to the motion again.
We have the first part of the motion that we've agreed to. What is the second part now?
You suggest to work with the advisory committee. You suggest to the advisory committee that they work with the tribal partners in coordination of the self-exclusion list.
I think that's great.
That's not what it was?
Oh, no. No.
I'm not sorry, going back. I'm not even sure it's necessary though. Like, I'm looking at the legislation. So section 6(2) says individuals and families impacted by problem gambling will benefit from the availability of a uniform self-exclusion program. And then if you look at sub B, says the program must have a process for federally recognized Indian tribes or tribal enterprises that own gambling operations to voluntarily participate in the self-exclusion program. So it's already in the legislation that's been proposed.
So are you withdrawing your amendment? Motion?
Yes. Not sure that it's necessary because I see it already in the legislation.
I'll offer that amendment then, as it stands. I'll offer it up.
Would it make more sense, maybe from what Executive Director Griffin was saying, to have this be done within the Gambling Commission, but I guess explore it and we can potentially make a motion later of working with tribes, but not to have it related to this committee at all? Would that?
I mean, so I'd be happy to provide details of the number of times that we have addressed this with tribes. This is an ongoing invitation, and the RCW says, you know, that this is voluntarily participation in the self-exclusion program. So I will need more direction as to how you want. So I can provide a summary of what we've done so far, and then I would be what I will need to make sure that I'm complying and that we're adequately addressing what your requests are, is what that will look like beyond what we've done already in context with the RCW.
I think Commissioner Patterson kind of just wants to look at so far the part about card rooms being disseminated to tribes, right? People that are on that self-exclusion list. And then
I'm kind of tired now and frustrated a little bit.
So we can certainly address that. Get back to you on that piece, but it was taking a more global approach. As
I don't know what your point was about the voluntary thing. What is that about?
that the tribes can, So what the RCW currently says is a state self-exclusion program must have a process for federally recognized Indian tribes or tribal enterprises that own gambling operations or facilities with Class 3 gaming compacts to voluntarily participate in the self-exclusion program.
Well, why is that relevant to this conversation?
Because what I thought I was hearing was that that staff was in one of these mini motions that staff was being directed to engage, and what I think potentially was lost is that we have engaged. We have over the years sought to engaged with the tribes to voluntarily participate in the self-exclusion program. Have we looked at your suggestion about just saying changing the form? No, we have not addressed that. And we can certainly do that.
I got to tell you, I'm kind of frustrated right now, and I just see that there's a big job ahead of us with regard to self-exclusion. Mm-hmm. And it is going to require this advisory committee to have some very interesting and dynamic conversations with the tribes about how we can make it possible for people with gambling addictions to self-exclude across the entire state of Washington, because they will want to do that. And I think that the tribes will want that to happen as well. And this isn't going to be easy. Figure out how to do that. I mean, it's going to be just as difficult as coordinating with every other state in the country to do this. In this state, because of the number of tribes we have, it's going to be just as difficult, in my opinion, because each one has a different way of doing this. And so that's all I'm trying to do. I'm trying to say that the Gambling Commission should highlight the fact that we need to emphasize the need to do this work. And so it doesn't look like we're all on the same page with that, and I don't want to stay any longer here. And maybe we'll have a conversation about this again, I hope. Maybe we could think about the best way to have a conversation about this, because I sense that we're really wrapped around the axle right now. So I'll withdraw my motion. But I do want to say that it's very, if you give me a moment, Madam Chair, it's very difficult for me, Commissioner Lawson, to constantly feel like that there's a sense that I am somehow or other impugning the tribes when I suggest that we do this work or any work with the tribes, or that if we question the tribes on anything, that all of a sudden we're not recognizing their sovereignty, or we're not playing nicely with them. We are partners with them. And so that's very frustrating for me. And I understand, there's a lot of history. I do understand that. Anyway, thank you, Madam Chair.
Thank you. Okay, any other thoughts or comments on tab 8? Are there any public comments? No. Yes.
Yeah. Do you want me to come?
Yes, please.
Okay. Thank you for the opportunity to respond or give public feedback. In my position as the manager of the State Problem Gambling Program, and I will likely be the facilitator for that advisory council, I just want to say that, first of all, my understanding and reading of the RCW and the language that applies to the advisory council is that, as you said, Director, we're going to be looking at those resolutions that we work so hard on, see how they're going. We're going to talk about any emerging issues that are coming up, and I think there was one other item on there. I don't see in there anywhere that we can make people on that advisory council do anything. There's nothing that's required that we have any power to do. So I really resonated, Commissioner Patterson, with the Gambling Commission endorsing the resolutions of the Nickel G resolution. and then sharing that through staff with the advisory council. And then if there's an additional piece around, does the advisory council, would the gambling commission like the advisory council through the staff or members to talk about brainstorming about how this might be that other issue around the voluntary self-exclusion program and how it works with the tribes. I can see that being a role that could happen in the advisory council. I just don't, the advisory council is not a make things happen as I view it kind of council. It's more of a, if there are members on the council, and there will be, like Evergreen Council and others that are already doing this work, commission staff, possibly commissioners, and they want to take that away and then continue to do that work, I think that's great, and that would be my hope. But I don't feel like HCA is in a role as the convener of this group to actually be able to make it a piece of work that the advisory council is doing itself. Does that make sense?
No, you're absolutely right.
Okay.
But the policymakers here, the gambling commission, could make a recommendation to you. We can't force you, we can't direct you, we can't force the tribes, we can't direct the tribes, but we can have an opinion about what it is that you should probably be doing. And that's what I was trying to do here.
Yeah.
Because we are policymakers.
Thank you.
You bet.
Thank you. Any other public comments? All right. Any public comment about any things on the meeting today? No, not seeing any. All right. Well, then our next meeting will be September 14th and 15th. This will be held at the Washington State Liquor and Cannabis Board. And that concludes our meeting today at 2:10 p.m. Thank you, everyone, for participating.
Thank you. Have a good rest of your day.